please invite the administration in. Tabled before members is a paper that we've just received.
佢改點名先，係好就唔該晒政府嘅幾位。
So, thank you for attending a meeting. I don't think I need to introduce the officials to members again. Now, there is a subcommittee meeting going on in another conference room, and some members are at that subcommittee, but they may come back later. So I think we can now invite the administration to take us through the paper. Yes, Mr. Ding will take members through the paper, Chairman. Good morning, members. Now, there are 3 points that we need to respond to. Details concerning the consultation, estimated total number of PHS apparatus, and also prosecution records. First of all, concerning the proposed withdrawal of licensing exemptions in respect of PHS apparatus, the former TA conducted 2 consultation exercises, namely an industry consultation and a public consultation. The TA first consulted the industry through the Radio Spectrum Advisory Committee at 2 meetings in October 2010 and March 2011 respectively on a proposed withdrawal of the relevant licensing exemptions. I want to point out that the RSAC comprises representatives from the Consumer Council who can give comments from the consumer's perspective. And then the former TA issued a consultation paper in November 2011 for a 10-week public consultation. Response to both consultation exercises indicated general support for the proposed withdrawal of licensing exemptions in respect of PHS apparatus. Having regard to the outcome of the public consultation exercise, the TA published a statement in March 2012 to announce his decision on the way forward with regard to the proposal. Further details about the 2 consultation exercises can be found in Enclosure 1. In fact, since 2002, the OFCA or the former OFTA has not received any application for certification of PHS apparatus under its voluntary scheme. And then in September 2010, there was a market survey conducted, and a former OFTA found that there was no PHS apparatus available in the local market for sale. To gauge the utilization of the PHS spectrum, OFCA regularly monitors the use of the PHS frequency band in various districts. And in fact, utilization of the PHS frequency band was extremely small. And based on the estimated lifespan of PHS apparatus, OFCA estimates that some 800 PHS cordless telephones are currently in use. We've mainly taken into account the battery life of PHS apparatus, and our best guesstimate is that no more than 50 sets of PHS cordless phones would remain functional by early 2014. And concerning how we've come up with the estimation, members can refer to Enclosure 2. And this document is technical in nature, and so we've only got an English version and there is no Chinese version. Now let me come to previous record of prosecution. From July 2009 to June 2012, with regard to enforcement against illegal telecommunications apparatus, the figures are as follows. Number of cases with enforcement actions 1229, number of prosecutions prosecution cases 867, number of non-prosecuted cases 362, number of confiscated telecommunications apparatus 3055. In the past 3 years, there were a total of 283 cases of genuine mistake or misunderstanding of the offense in relation to the illegal possession or use of telecommunications apparatus for domestic purpose. Ofcom did not institute prosecution in any of these cases. The subject apparatus was confiscated. Ofcom will continue to adopt such enforcement practices in future in relation to PHS apparatus. Thank you. All right, let's ask whether members have got any questions. Members are still reading the paper, so perhaps I can ask one question first. The former OFTA or the present OFCA conducted consultation exercises, and the documents and the statements were all available on the website. And so I think in future, when you provide us with papers, you can also enclose such documents. Now, we're told that at the moment only about 800 PHS phones are in use, and the number will be no more than 50 by early 2014. Now, so we do have confidence in your professional assessment, but can I now ask you this question? Can we wait for 3 more years? Now, we understand that there is a need to make available the spectrum for mobile telecommunications use. We need to strike a balance. So do you think waiting for 3 years will be too long? And then second, may I refer to the prosecution figures? Concerning the 200 odd cases, with regard to illegal possession or use of telecommunications apparatus for domestic purpose, there was no prosecution action, and the apparatus was confiscated. But then concerning the prosecution cases, can you tell us under what circumstances you take prosecution action? Chairman, concerning the 3-year grace period, the objective is to strike the right balance. So we are of the view that there will be few PHS cordless phones in use after the grace period. And then, Chairman, concerning the figure 867, we're talking about prosecution cases involving illegal use of telecommunications apparatus, for example, trucks, taxis, or freight companies, and we take prosecution action if we discover such unlawful use of telecommunications apparatus, because in most cases the offense is committed knowingly. And then secondly, as they are in this business, they have to make sure that when they use the telecommunications apparatus, that such apparatus must be lawful or legal. So you're mainly talking about communication or radar use, communication use. Mr. Wu Chi-wai. Thank you, Chairman. I have a simple question. So, a 3-year grace period is proposed because the administration needs the spectrum for other users. And then we're told that at the moment there are only 800 such phones currently in use. So can I ask the administration what it's going to do when the spectrum is recovered, because we don't want the spectrum to just lie idle there after it has been recovered. So what are your next steps, please? Chairman, concerning the use of the spectrum for mobile telecommunications purposes, I understand that the industry is very concerned, and in fact every year we do earmark frequency band or spectrum for use by the industry, and there will be discussion in the industry, and so we will inform the industry, and we will put this frequency band in the schedule of frequency band to be made available for use by the mobile telecommunications industry. And we'll also monitor international developments to see how that frequency band should be used. Say, for example, for 3G or 4G service. And we will auction the spectrum through the market mechanism. So we'll closely monitor the development. I'm sure the industry will monitor such developments even more closely. Now, because our spectrum, radio spectrum, is valuable and scarce public resources. So I want to know when there will be a consensus reached with the industry so that the spectrum can be auctioned. Chairman, we need to do public consultation and consultation within the industry, and then we'll inform the industry of the availability of the spectrum. And I think this process takes about a year. But of course, we'll always bear in mind market demand. So do you have to wait till the spectrum is entirely clean before you trigger or start the process? Or can you start the process next year? Now, from a technical point of view, a frequency band can't be entirely clean. In fact, we do receive reports or complaints from time to time, so we don't need to wait till the spectrum is entirely clean, so to speak, before we start the consultation work. But we'll closely monitor the use of the frequency band, and if we are confident that the interference will not be serious, then we will consider auctioning or putting up the spectrum or frequency band for auctioning. And then subsequently, if there is interference, then we will try to trace the interference in accordance with the law and remove the interference.
Mr. Ronnie Tong, Para 6. Says that in the past 3 years there were a total of 283 cases of genuine mistake or misunderstanding of the offense in relation to the illegal possession or use of telecommunications apparatus for domestic purpose. I'd like to know whether this 283 cases is included in the 362 non-prosecuted cases in Para 5. And 386 minus 283, we still have 80 odd. So what were these cases? And at the last meeting, I said my worry was the basis for non-prosecution. Now, if we take a look at the notice, we are amending the scope of exemption. Now, if a person is in possession of such apparatus and is not exempted from the requirement, then he may face prosecution. So, under what basis can the TA confiscate an apparatus without prosecution? I'd like to know, I'd like to read the current legislation. Because in the current legislation, on notice is about amending the scope of exemption. All right. There were 283 cases involving domestic use of such apparatus, and they were not prosecuted. Of course, they were counted towards the 362 non-prosecution cases. Then the balance is around 80 odd cases where there was no prosecution. For instance, in some cases, there was insufficient evidence after investigation, and in some cases, the suspect was not traceable because the company had already closed. And then some others were technical breaches. Yes, there was no, it was not licensed, but an application might be under, it was in process, was being processed. So we believe that under such circumstances, prosecution is not necessary. Thank you. Chairman, what about the basis of enforcement? The legal basis. Under what provision can you confiscate an apparatus without prosecution? I will invite DOJ to supplement. Let me share with you our enforcement experience and practice. If a member of the public inadvertently, well, we've said this and we've heard this a number of times, we're concerned that the enforcement agency might be selective in enforcement. Because our worry is that you can selectively prosecute somebody and not others. So you may be well-intentioned, but the problem is when the legislation is in the hands of not so well-intentioned law enforcement officers, then we're worried that it can be used to bully some parties. Because I dislike so much discretion in the law, because a law enforcement agency may say that because I don't like your look, I prosecute you. So I'm asking for the legal basis for your selective action. Because this is a legal point if there is no legal basis. And if you don't prosecute a person, how can you confiscate his apparatus? Because if you decide not to charge him, that means he has not breached the law. In that case, you can't confiscate his apparatus. If you do, that means he has breached the relevant legislation. Thank you, Mr. Tong. The TA and the DOJ has an understanding in terms of prosecution. We still need time to provide the supplementary information, but we do appreciate Mr. Ronnie Tong's concern. Yes, because it involves the DOJ, because the DOJ has delegated some of its prosecution authority to the TA, and we have to review, or we have to go back and check the criteria. At least show us the relevant provisions in the ordinance. For instance, the penalty and the provisions to allowing you to confiscate PHS apparatus, so on and so forth. Regarding confiscation, is found in Section 36 of the Telecommunications Ordinance. Section 36 of the Telecommunications Ordinance. Well, but I'm afraid I don't have the ordinance with me. Perhaps the legal advisor has got it. Well, it's impossible for me to download or to bring along with me the whole set of Hong Kong laws in each meeting. So I don't have the legislation with me. Perhaps we give the floor to Mr. James Teo first. So do you have further points to make in relation to Mr. Tong's question? Please refer to Section 36.
至可以沒收嘅，即係話你係要告咗佢就可以沒收嘅，你唔可以未告佢係沒收嘅。咁呢啲就正正我得。
That means that you can only confiscate the apparatus when you charge a certain party, and this is exactly my concern. But let me supplement. Section 36 also says application by any public officer. I'm afraid it's application by any public officer. It's not that the public officer can make such an order. This is about the grammar. All right, it's like this, Chairman. If a certain apparatus is expected to be operated in breach of the Telecommunications Ordinance, then a public officer, including an officer of the TA, can apply to the magistrate. Yes, you have to apply to the court or the magistrate, and you can only confiscate a certain apparatus under the order of the court. So, well, if you had given this answer earlier on, I won't have to say so much things. Now, because I'm worried, because on the street, you may say that I don't like your phone. I want to confiscate it. All right, that part about confiscation is okay, but what about selective enforcement? Mr. James Teo? I beg your pardon because I had to consult a Chinese medical practitioner. Enclosure 3, I'd like to know whether there's been any explanation. I think I understand, but I am worried that I'm not, whether my understanding is correct. Enclosure 3, Mr. Ding. Well, for PHS apparatus, they are older in style, and they will be using an embedded battery and nick cap, and the member effect is rather bad, but subsequently a new type, the battery life is limited, and according to information, such battery can be recharged for 500 to 1,500 times, and the average is about 1,000 times. So from 1,000 to 1,500, the standard deviation, if it is 3, is about 99.7%, and we expect a bigger spread. So the mean is 1,000, standard deviation is 250. That's the recharging cycle, and we assume that a battery, usually the battery life is about 5 years, but I think this is already an estimation on the high side. Usually it's 3 to 4 years. So using 5 years as the mean life, that would translate into 1.5 years. That's the standard deviation. So 5 year is the mean and 1.25 is the standard deviation. Well, in the year 2000, it was the last application for PHS approval. We assume that the peak sale period occurred in the following 2 years up to end 2004, and we assume that 5% of the households were using PHS, and that's well, the number of households was 2 million, and so that means 100,000 households were using PHS. But as at end 2004, there was only 12 such approvals. At the same time, there were 300 odd dent phone being approved. So right from the beginning, there were only very few models of PHS. So but an estimation of 100,000 households is already very high. So in end 2004, the number of households using that was to 100,000, and then a standard deviation is 1.25, and the mean is 5 years. So it's about 2.4. And you look at the table of normal distribution is about 820. So if we use the high side estimate, it will be about 800. If we do not adopt the high side estimate, then it will be scaled down, so there won't be as many as 800. And if the normal distribution is up to 99.95%, it would be early 2014, only 50 will be left. Using normal distribution, in mid-2015 there would only be 1 left. But the characteristic of normal distribution is the tail can be very long. Anyway, in around 2015 and 2015, there would be no more PHS cordless telephone left. Mr. James Ho, I will support the amendment of the ordinance based on Annex 3 to Enclosure 2. Of course, there are assumptions used here, but I am satisfied that this calculation is more or less correct, because of course there might be the possibility that somebody purchased an extra battery, or perhaps the box was not opened, was never opened, but the possibility is very, very low. Of course, such phones might be a few $1,000s in price, and a certain person, somebody may purchase an extra battery, although not many, but I'm one of them. Sometimes I will buy 1 or 2 extra pieces of battery because I know that's the bottleneck.
Anyway, I am inclined to believe that we should not be talking about tens of thousands of such phones, or a few thousand such phones. And so I, from the point of view of a legislator, feel that there won't be too many such phones in use, and so I think my query has already been cleared. Yes, thank you, Mr. James Toh. I agree with you. I think I can endorse this estimate in Enclosure 2 to Annex 3. Do members have other follow-up questions? Last time we asked whether there was a need for us to meet deputations, and members are shaking their heads. So let's now move on to clause by clause study. Yes, please. So Chairman will now start the clause-by-clause scrutiny of the Telecommunications Apparatus Exemption from Licensing Amendment Order 2012. So this is in relation to PHS phones, and so we need to look at Cap 106 subsidiary legislation EZ. First of all, commencement. The amendment order will commence on a date specified by the OFCA. So this to come into operation on a date to be appointed by the Director General of Communications by notice published in the Gazette. And then there is a need to provide for an interpretation, because we need to provide for a 3-year grace period. And then Section 5. Now, in fact, this spectrum of frequency band is within Section 5 of sublet is set. So you can see that the frequency band is in Schedule 2 of the sublet is set. Right, members have any questions in relation to Section 5? No, then we can continue. So Section 5 includes all the frequency bands in Schedule 2, but now we need to have a new Schedule 3, and that's why we have 5(1)(a), which provides for exemption. We're talking about Section 8(1)(a), 8(1)(b) of the principal legislation, possession and use. But then 1C and 1D will cease immediately upon the commencement of the order, for example, sale or demonstration in the course of sale. And so 5(1)(a) provides for a 3-year grace period in relation to 8(1)(a) and 8(1)(b). So subsection 1A expires at midnight on the date immediately before the 3rd anniversary of the commencement date of the 2012 Amendment Order. All right, any questions? No? And then Section 6. We have this new 6(4). 6(4) states that a person who is required under Section 8(1)(a) or (b) of the ordinance to a license is exempted from that requirement if the apparatus is used or is capable of being used in a combination of a manner described in Section 3(1) and a manner described in Section 5(1)(a). And also the relevant provisions in Sections 3 and 5 are complied with. And again, the grace period is 3 years. No questions? Please continue. We need to amend Section 7 as well, Chairman, in relation to import and export of radio communications apparatus. Because when the order commences, import and export of PHS apparatus will be banned, and that's why Section 5 or 6 is repealed and substituted by Section 5(1) or 6(1), 2, or 3. So 5(1) and 6(4). We have these, and so when the amendment order comes into effect, import and export of such apparatus is banned. And as I've said just now, the PHS frequency band is in Schedule 2, and so we need to take out the relevant frequency band from Schedule 2 so as not to affect other exemptions. No problem. Please continue. So in Schedule 3, we have this frequency band. Because the grace period is rather long, it's 3 years. And so we need to have the grace period in the subsidiary legislation. And that's why we have this new Schedule 3 created. Yes. No questions. No questions. Right, members? Do you have any further questions or comments? So tomorrow, at the sitting, I will move that the scrutiny period be extended to the 27th of February this year. And then we'll report to HC on the 8th. If members want to amend the order, they must give notice by 20th of February so that the amendment can be moved on the 27th of February. Right? Any questions concerning the timetable? Can I ask the administration when the amendment order will take effect? So we will liaise with the DOJ before the commencement, and so there will be a commencement order, and the commencement order will also need to come to LegCo, and so we believe that this amendment order will come into effect in May. All right. Any other questions? So members are satisfied with the reply from the administration, in particular the estimate of the number of such phones still in use in the market. And then I believe members have no further questions on the prosecution cases, but of course Mr. Ronnie Tong would want the administration to give a written reply concerning the criteria for deciding whether to take prosecution action or not. And then members will, after receiving the reply, decide whether a further meeting is required. So we hope to get a written reply from the administration. So when will you be able to give us that reply? We'll report to the HC on the 8th of February. So in other words, you must give us the paper before that date, maybe 1 week. So can you give us the reply by the end of January? Just in case members want to put further questions to you. All right? All right. So I think we don't have AOB items today. So I think we can adjourn the meeting. Thank you.
唔該晒。